In this lecture, we would like to discuss about alteration of memorandum of association of a company as per the provisions of the Companies Act 2013. So, in that regards, the register of the companies have all exclusive powers as provided under section 13 subsection 6 clause A. The register shall register any alteration of memorandum of association with respect to the objects of the company and certify the registration within a period of 30 days from the date of filing of special resolution by the company in accordance with the provisions of this section. So, the very special resolution must be passed by the company as per the provisions of this section, section 13 clause, subsection 6 clause A. But however, section 13 subsection 1 declares that no alteration made under section 13 shall have any effect until it has been registered with the register of companies. And as per the provisions under section 13 clause subsection 10, any alteration of memorandum of association in case of the company limited by the guarantee and not having a share capital purporting to give any person a right to participate in the divisible profits of the company otherwise than a member shall be valid. So, now we would like to discuss those alterations as provided under the Act, and in regards to that, first we would like to discuss the alteration of the Memorandum of Association in regards to change of name as it is provided under Section 13 of the Companies Act of 2013. So, as it is provided, a company may be by special resolution and with the approval of the central government signified in writing change its name, but no such approval shall be required where the only change in the name of a company is the addition thereto, or as the case may be, the deletion of therefrom of the word private subsequent on the conversion in accordance with the provisions of the act of a public company into a private company or of a private company into a public company as it is provided under section 13 of the Companies Act 2013. If through inadvertence or otherwise a company's name is wrongly registered by a name which in the opinion of the central government is identical with the name of by which a company already in existence has been previously registered under the register of the companies. The name of the former company may be changed by passing an ordinary resolution and with the previous approval of the central government in writing. Now we would like to go to the second important alteration of memorandum of association of a company as regarding the very alteration of objects of the company as provided under section 13 subsection 6, section 13, subsection 1 and section 13, subsection 10. So, as it provides the register of the company shall register any alteration of memorandum of association with respect to the objects of the company and certify the registration within a period of 30 days from the date of filing of special resolution in accordance with the provisions of section 13, subsection 6 and clause A, which provides that the special resolution in regard to alteration of its objects of the company passed by the company. However, Section 13 clause 1 declares that no alteration made under Section 13 shall have any effect until it has been registered with the register of the companies. As per the provisions of this section, we found under the Companies Act 2013. So also, any alteration of memorandum of association as provided under section 13 subsection 10 in case of the company limited by the guarantee and not having a share capital by the purporting to give any person a right to participate in the divisible profits of the company otherwise than a member shall be void as it is provided under section 13 subsection 10 of the Companies Act 2013. Now we would like to discuss the third alteration of Memorandum of Association in relation to alteration of share capital as it is provided under section 61 of the Act. So, a limited company having a share capital may, if so authorized by its articles of association, alter the conditions of its memorandum of association in regard to the following. So, it could increase the share capital by issuing new shares. So also, it could consolidate and divide its share capital into shares of a larger amount than its existing shares. So also, it could alter in the memorandum of association to convert its fully paid off shares into stock and reconvert that stock into fully paid off shares of any denomination. So also, in doing the very alteration of share capital as per the provisions under section 61, it could subdivide its shares into shares of smaller amount than is fixed by the very memorandum of association. So also it could cancel shares which at the date of passing of the resolution in that behalf had not been taken or agreed to be taken by any person and diminish the amount of its share capital by the amount of the shares so cancelled. Such power shall be exercised by the company itself in general meeting and require no confirmation by the court, nor shall such cancellation of shares be deemed to be a reduction of the share capital. So, this is all regarding alteration of share capital as regarding to alteration of memorandum of association as provided under Section 61 of the Companies Act. And now we would like to go to the fourth one, and that is reorganization of share capital as provided under Section 391 of the Companies Act. So, under this very section, the tribunal may sanction a scheme of arrangement between a company and its creditors or between a company and its members so as to reorganize the share capital. And the fifth one that we found regarding alteration of memorandum of association as provided under section 66 of the Companies Act of 2013, that is relating to reduction of share capital. So, subject to confirmation by the tribunal, a company limited by shares or a company limited by guarantee and having a share capital may, if so authorized by its articles of association, by a special resolution of the company, reduce its shares capital by extinguishing or reducing its ability on any of its shares in respect of share capital not paid off, and cancelling any shares in respect paid off share capital which is lost, and so also paying off any paid off share capital which is in excess of the wants of the company and may alter its memorandum by reducing the amount of its share capital and of its shares. And accordingly, the very provision in relating to alteration of memorandum in the connection of reduction of share capital as provided under Section 66 of the Companies Act 2013. Now we would like to go to the sixth one in relation to alteration of memorandum of association in connection to creating reserve liability of a limited company. So in that connection, would like to discuss a limited company may by special resolution determine that any portion of its share capital which has not been already called up shall not be capable of being called up except in the event of the company being wound up, and thereupon that portion of its share capital shall not be capable of being called up except in that event. And now we would like to go to the seventh one in regards to alteration of memorandum of association in connection to that special resolution of limited company making liability of directors unlimited. So, a limited company may, if so authorized by its articles, by special resolution of the company, alter its memorandum of association so as to render unlimited the liability of the directors of the company or of any director of the company, even the manager of the company, upon the passing of its such special resolution by the company, the provisions thereof shall be as valid as they had been originally contained in the memorandum of association of that company which was originally registered under the register of the companies. And alteration in the memorandum of association does not require confirmation by the court. And finally, the eighth point that we would like to discuss in relation to alteration of memorandum of association in connection to this would like to analyze the very provisions of section 48 and section 117. So, that is alteration of rights of holders of special classes of shares. So, in that regard, we would like to discuss where the share capital of a company is divided into different classes of shares. The rights attached to these shares of any class may be varied with the consent in writing of the holders of those shares of not less than 3/4 of the issued shares of that class, or with the sanction of a special resolution passed at a special meeting of the holders of the issued shares of that class by the company. If provisions with respect to such variation is contained in the memorandum or articles of the associations of the company, or if the absence of any such provision in the memorandum or articles of association, if such variation is not prohibited by the terms of issue of the shares of that class, as it is provided under section 48 of the Companies Act 2013. So also the alteration of the memorandum being having the alteration of the conditions within the meaning of section 16 subsection 2 and being an alteration made by special resolution, it must be filed with the register of the companies as provided under section 117 of the Companies Act 2013. So such alteration in the memorandum of association is only possible if permitted by its articles, where the articles of association are silent. This has to be provided for in the articles itself first before carrying out any alteration in the memorandum. So, in this lecture, we have discussed regarding alteration of memorandum of association of a company which is registered under the register of companies, and when such alteration would be made by a special resolution of the company in regards to the change of name, by following the very provisions provided under section 13 of the Companies Act 2013, and also in regard to alteration of the very objects of the memorandum of association of the company as provided under section 13 subsection 6, section 13 subsection 1, and section 13 subsection 10, and also in regards to alteration of share capital of the company as it is already provided in the original registration before the register of companies in the very memorandum of association, and if any alteration would be made in that connection in regards to share capital, the provisions of section 61 of the Companies Act should be followed. Then another alteration in regards to memorandum of association in reorganization of share capitals, as it is provided under section 391 of the Companies Act. So also, the next alteration on in regards to memorandum of association, in regards to reduction of share capital, and that is provided under section 66 of the Companies Act 2013, and also another alteration in regards to memorandum of association of the company is creating reserve liability of a limited company. And the next alteration of memorandum of association of a company is relating to special resolution of the limited company, making liability of the directors of the company unlimited. And finally, the next important alteration in regards to memorandum of association of a company is relating to alteration of rights of holders of special classes of shares, and as it is provided under section 48 and section 117 of the Companies Act 2013. So in our upcoming video, in brief, we would like to discuss the very effects of alteration on the memorandum or articles of association of a company.